Thank you. So we'll resume our second half with Sam Hopper speaking on disclaimer of a lease by a landlord's liquidator, the Court of Appeal decision in Wilmot. Sam is also a property law specialist, although he has a significant part of insolvency in his practice as well, and hence the paper that he's speaking to this morning. He's been involved in a lot of the large insolvency matters in recent times: Timbercore, Great Southern, Forestry Enterprises, Guns, etc. So he brings a degree of, or a wealth of expertise to his presentation. Sam's been at the bar about 10 years. He's a member of the Law Institute of Victoria's PEL's Leases Committee, the Australian Property Law Group Victoria Committee, and he's engaged to assess exams for candidates seeking to be qualified as accredited specialists in commercial tenancies with the LIV. So that makes him a hard man. I think those exams, they tell me, are pretty tough things. One thing I would refer you to of Sam's, it's probably in the CV there, I think, or the bio, is Sam runs a very good property law and insolvency blog. samhopperbarrister.com is the address I've got here. Sam sends copies of it to me, and I must say they always seem very practical and to the point. So if you're not aware of it, I'd recommend it to you. Please welcome Sam Hopper.
Thanks, everyone. When I arrived, I saw the microphone, the roving microphone on the table there, and felt like I'd just arrived on stage in the blind auditions of The Voice, and I was expecting a few of you to sit at the front with your seats facing backwards. And it reminded me of a time just recently I overheard my daughters, aged 2 and 4 respectively, in their bedroom. And one of them was singing. I stuck my head in to see what was going on. One of them had turned her seat round at one end of the room and had her back facing her sister while she was performing. And she said, "I'm Delta, I'm Delta." And the 2.5-year-old said, "I'm Joel Madden," and then tried to pick up a texter to write on her arm. Now, I'm talking about a recent decision which I think is a bit of a hot topic in lease world at the moment. That is the Court of Appeal's recent decision in Wilmot Forests. It was originally the subject of a decision before Justice Davies. It was appealed to the Court of Appeal and the decision was handed down late last year, and there is an application for special leave to appeal the Court of Appeal's decision that's being heard by 2 judges of the High Court tomorrow. That won't, if special leave gets up, the special leave application is successful, that won't overturn the decision. There may be a further hearing down the track. However, if the application for special leave is unsuccessful, then the Court of Appeal's decision will stand. Now, to give you the very brief overview of the Court of Appeal's decision is this. The Court of Appeal said that a liquidator appointed to a landlord company could use the disclaimer power under the Corporations Act to unilaterally extinguish all rights held by a tenant of the landlord company. Right. So that's the sort of threshold issue in this case. Now, to give you some of the background, Wilmot Forests was yet another of the forestry and agricultural managed investment scheme companies that's fallen over in the last few years. And most of you would probably have heard of names like Environinvest, Timbercorp, Great Southern, Tasmanian Forestries that have all, and Elders that are having some trouble, although haven't tipped over yet. And of course Guns in the last few years as well. Now Wilmot was, like most of those, a large group of companies. There was one company that was appointed as the responsible entity, and there were also landowning companies involved. Now, a managed investment scheme is, for those who aren't aware, is a form of statutory regulated trust. It's effectively a trust regulated by Chapter 5C of the Corporations Act. The responsible entity is the form of trustee who has some additional duties imposed on it by the terms of the Corporations Act. And the usual structure of these schemes is to have land held by a land-owning company within the corporate group. The land-owning company will grant a head lease to the responsible entity, who becomes both the trustee and immediate landlord of the investors, who all get a sublease in the respective land, the land on which the operations are going to take place, and they usually get either a quarter of a hectare or a hectare of land per unit in the investment. The value in the investment is the trees in the ground. In this case, it's a forestry scheme. Sometimes it's almonds, olives, table grapes. There's all sorts of different schemes, but most of them are forestry, timber. There's a real issue in the law over whether it's possible for someone to own a tree planted in the ground who doesn't own the land, because the tree is a fixture. Title to the fixture vests in the landlord, and they may have some contractual or other rights in relation to the tree, but there's a question mark over whether it's possible to own the tree before it's chopped down. Now, in order to protect the members' investments in the trees, ASIC usually requires that a property right be held either for or on behalf of the investors that will secure their rights to chop down the tree and turn them into chattels that then vest in the investors. So that's why we have this structure of landowning company, responsible entity having a head lease, and usually a sublease in favour of the investors themselves, who are referred to throughout the scheme documents as capital G growers. Now, the Wilmot managed investment schemes follow the same basic structure. In fact, the RE was the landowning company rather than a head tenant, and just granted direct leases to the tenant, but to the growers. But I don't think that makes any difference for the purposes of our discussion today. Now, when one of these schemes falls over and the responsible entity is placed into administration or liquidation, you invariably end up with a competition between the growers on the one hand, who are looking to preserve the value of their investment in the trees, and they're looking to preserve that by preserving their leases, because that's the security for their investment in the trees. On the other hand, you've got a bank or a syndicate of banks who have financed usually the acquisition of the freehold land, and who have mortgages and charges over the relevant assets held by the landowning company, which is higher in the chain of title. And the receivers will want to sell the land free of the growers' leases, because if the growers' leases are extinguished, they can sell the freehold unencumbered, and they can effectively sell the value of the trees. The land is very hard, the encumbered freehold becomes very hard to sell, the unencumbered freehold becomes very valuable. So once the insolvency starts, you have a competition and a bit of a race to try and extinguish the growers' rights, or if you're acting for the growers, to try and preserve the growers' rights, and in the case of the banks, to then try and sell the unencumbered freehold. And it's in that context that, well, just to go back a further step, there were various steps that have been taken in earlier proceedings that in other insolvencies that different ways that were used by the receivers and liquidators to extinguish the growers' rights, and they're all the usual ones we're aware of, terminations and repudiations and non-payment of rent and extinguishment of superior titles in the chain that would have the effect of extinguishing the subordinate rights. In this particular case, because the growers had a lease directly from the landowning company, there were no superior titles that could be interfered with, and the leases themselves consisted only of payment of rent up front and no substantial onerous covenants throughout the term of the lease. So there were no defaults on forfeitures on which the lease could, that could support the service of a Section 146 notice, and there was no other way to terminate the leases. So the liquidators came up with a plan of using the disclaimer power in the Corporations Act to extinguish leases. Now, the disclaimer power is a power granted to liquidators, but not to administrators or receivers. It's granted in order to allow a receiver to extinguish certain onerous, extinguish the company's interest in land burdened by onerous covenants, or to rid the company of unprofitable or troublesome contracts that would have the effect of allowing the company to liquidate, or the liquidator to liquidate the company's assets quickly and efficiently for the benefit of creditors. Now, it's very common for a liquidator appointed to a tenant company to use the disclaimer power to say, oh, the company's got a lease of an office, we're winding up the company, the lease has got 10 years left to run, I don't need that lease anymore, the company doesn't need that lease anymore, the creditors of the company don't need that lease anymore, I'll disclaim it. And the lease goes, effectively, the interest in land goes back up the chain of title, and the landlord can, if it wants to, approve in the liquidation for a loss of rent for the balance of the term of the lease, if he thinks there's any value in doing that. But the liquidator is able to wash his hands of any concerns associated with that lease. What hasn't really happened before is the reverse, where a landowning company has a tenancy and says, well, I want to rid myself of that troublesome tenant and sell the freehold without the lease. So the liquidators, there's one unreported decision from a master in Queensland that records a similar thing happening, but that's the only example that we've been able to find of a landlord company's liquidator trying to disclaim a lease. Now, as it's an unusual step, and these are quite high value schemes, the liquidators took the prudent course, which is to make an application to the court for judicial directions. That is effectively a form of judicial advice that tells them whether or not they are entitled to do what they propose to do. They made an application before Justice Davies, and they said they sought judicial advice to say whether to advise them whether or not their disclaimer of these leases would be effective. Justice Davies heard the application, and she said that while the disclaimer by the landlord, I'll go back a step, she said a lease, it's uncontroversial that a lease is both a contract and a demise. Right? We know that since Progressive Mailing House and Bali. And she said that the liquidator may be able to disclaim the contractual component of the lease, but the estate in land, the interest in land that's demised to the tenant is the tenant's land and is not the land or the property of the company in liquidation. So she said that if the liquidator were to disclaim the lease, the tenant's interest in land would survive, so the disclaimer would not be effective to give the liquidators clear title over the freehold. Okay? Now, that was then appealed when the question got quite a bit more complicated on appeal. New barristers were briefed by the liquidators, and the case on appeal raised the decision of Justice Dean in Progressive Mailing House and Tabali. And in that case, Justice Dean traces through the history of and the development of leasing law away through from its medieval origins through to its modern iteration, which is a combination of a contract and an interest in land. And they seized on some passages in that decision that said that in the context of discussing whether or not you could extinguish a lease by acceptance of the tenant's repudiation, that the extinguishment of the contract will also extinguish the estate in land. And that's because they said that the estate in land and the contract are part of a single transaction and can't be separated. And Justice Dean said that the promise that the contract rests, his words were, that a lease rests in covenant rather than in estate, which is a code for saying that the contract, at least for the purposes of a disclaimer, is what truly governs, sorry, not disclaimer, repudiation, is what truly governs the nature of a lease. So the Court of Appeal liked that argument, and they said that the disclaimer would be effective to extinguish not only the contract but also the estate in land, and a liquidator's disclaimer, when appointed to a landlord company, would extinguish all of the rights in a tenant's hands and give the landlord clear title, leaving the tenant with a right to prove in the liquidation for its losses, which is of course usually unsatisfactory, or to seek to set aside the disclaimer, and I'll come to some of the hurdles that they'd face in that in a moment. Now, for old-fashioned property lawyers like me, of course, this is horrifying, because you think, well, a lease is a man's castle. How can some landlord's liquidator unilaterally extinguish a tenant's rights? Now, the grower group from in the Wilmot case rallied their resources, and they have issued, they've filed an application for leave to appeal that decision. It's being heard tomorrow. I won't say too much about it because I'm in it, so I can't express. It's probably not appropriate for me to express views, although it's pretty obvious, given that I'm for the tenants' camp, what my views are going to be. It's probably better to turn now to some of the implications for practice while the decision stands. If the decision is overturned, obviously everything returns to normal. At the moment, the Court of Appeal's decision represents good law, and we all need to be aware of it. The implications for practitioners, I think, are this: when you're advising a tenant, it means that there is a risk which probably has a low risk of eventuating, but if it eventuates, could be devastating for the tenant. And that if the landlord is placed into liquidation and the liquidator decides to disclaim the lease, then they've got very limited recourse. If they want to prove in the liquidation, they're likely to get cents in the dollar, if that. The options for well, in fact, that was best described to me by a friend of mine who said that it's a bit like being told before you get your appendix out that there's a risk that you can die on the operating table. Chances of it happening would appear to be pretty low, but if it does happen, it's going to be utterly devastating. Now, there are two schools of thought as to the extent to which the extent of this risk. Some people have suggested that really all landlords appointed to, all liquidators appointed to landlords are going to want to preserve whatever revenue stream they have over the property, and are unlikely to want to disclaim leases outside the managed investment scheme context. Other people take the view that everyone should run for the hills, your leases aren't safe. The only comment I've got on that is that the decision of the Court of Appeal came down, I think, on a Wednesday. The reasons were published on the Thursday. I did a blog post on it on the Friday, and a couple of other people wrote about it on the same day. I was briefed to start a trial the following Thursday, which was a competition between a receiver and a rogue tenant. I was for the forces of good, obviously, the receiver, so the tenant was a rogue. The receiver, after that decision came down, the receiver got in contact with the liquidator that was also appointed to the landowning company. They made a reference to the Court of Appeal's decision in Wilmot told the tenant that they were going to disclaim the lease and they'd have nothing, and the tenant bought the mortgage out for pretty much full value. Now, it may well have settled anyway, I don't know, but I can say that within days, on a case that I was involved with, the decision was used and a settlement in negotiations, and a settlement followed very quickly thereafter. So I think it has the potential to play a role in quite a lot of cases and be a reasonably significant decision. The other issue is that the Court of Appeal, when they were analysing the leases themselves and some of the qualities of the leases in this particular case, one of the arguments that was put to the Court of Appeal was that this is a lease, a particular kind of lease that's more like an estate in land than a contract, because rent was paid up front and there's limited, if any, onerous covenants placed on either parties during the term of the lease. The Court of Appeal, in their decision, rejected that argument and said that for various reasons that I don't need to take you to, this is a part of a complex suite of commercial documents, and it's very similar to a shopping centre lease, and the clear implication of that paragraph is that the disclaimer power would be applicable to a landlord, a liquidator appointed to the landlord, or the decision would be applicable to the liquidator appointed to the landlord of a shopping centre. So I don't think it's that great a stretch to have, for example, to consider, for example, a liquidator appointed to a shopping centre that's not doing well at the moment, or perhaps a strip of shops on somewhere like Chapel Street. The shops aren't doing well, liquidator forms, and you've got, say, 2/3 occupancy and you've got a few vacant tenancies. Liquidator may form the view that the best way to get a return for creditors is to sell the land with vacant possession to a developer who wants to redevelop it as a hotel or as a residential tower. I don't think that's a far-fetched scenario, and you could really see a liquidator in those circumstances saying, okay, well, I've got 2/3 occupancy in my premises, let's disclaim those leases, they can prove in the liquidation, and we can get a better return for the creditors as a whole by doing that. So I think there's some real risk there for all tenants, whether they're commercial, retail or agricultural. Now, the other thing then is you say, okay, well, if this does happen, what are the tenant's options? Well, option number one is obviously to prove in the liquidation for your damages, get cents in the dollar, and if your tenant is a say a retail shop, you'd have to prove your loss and damage by either a net present value calculation or a business valuation, and you'll have arguments about that, and it'll be a very expensive and difficult process, not one that's likely to produce a very satisfactory return for a client. The alternative is to seek to set aside the disclaimer, and there's a provision in the Corps Act that allows a person who has suffered prejudice as a result of a disclaimer to make an application to the court within I think it's either 10 or 14 days of the disclaimer. It's a very short period of time. They go to court and they need to prove that the prejudice to the tenant in this case is grossly disproportionate to the prejudice to the creditors of the company. Now, for, say, there's no case law for our purposes on what gross disproportion is going to be for a tenant in these circumstances, because we just haven't got a body of case law yet, because this is the first time it's really happened, apart from that one incident in Queensland that I've referred to. But it may be that the courts form the view that all the tenants are losing an interest in land, so it must be grossly disproportionate, because that must outweigh the prejudice to the creditors of the company. That would seem to be unlikely, because that's a very medieval view of the magic of property as opposed to the modern money economy. So we're yet to see what would be gross disproportion in these kind of circumstances, but I think it's probably fair to say that if you're balancing the scales between the creditors of the company and the tenant, you'd need to say it's more than 51% in favour of the tenant, because grossly disproportionate would suggest it's a lot more than just a little bit more prejudicial to the tenant. So that, it seems to me, would be a fairly high hurdle that the tenant would need to get over in order to set aside a disclaimer, leaving aside all the usual forensic difficulties that a tenant's going to face in terms of the costs of litigation, the time involved, the short time frame in order to bring the proceeding on. So I think that if the High Court either doesn't grant leave to appeal tomorrow, or if ultimately they grant leave to appeal and the decision stands, the consequences for practice for practitioners acting for tenants are really quite significant, and it should be something that you're at least putting into your boilerplate advice whenever you're advising tenants that there is this risk out there. It's probably a risk you can't avoid, and you're just going to have to live with it for the time being.
The question is, can we do anything in future transactions to draft a clause in a lease that protects the tenant to bind a future liquidator? Of course, we don't know a future liquidator. We do know who the bank is, so we get mortgagee's consent. So can we bind a future liquidator not to exercise the disclaiming rights?
I don't see how you could, because the company, the directors of the company, landlord company now, I think would I can't see how they would be able to fetter the liquidator's discretion, because the liquidator is acting for the benefit of the company. And if there is a promise not to exercise the disclaimer power, why couldn't the liquidator disclaim that promise?
Michael Markowitz from Moran Agnew. Sam, given that how far contractualisation of leases has advanced, and leases themselves, particularly long-term leases, can themselves form the subject of security mortgages over leases, what do you see as the worth of a leaseholder stating land as a security from a financier's point of view?
I've always thought they're problematic. But I think it's as significant for a tenant's financier as it is for the tenant. I don't think I can put it go any further than that. It genuinely means that the tenant and the tenant's financier are taking a solvency risk as not only to their landlord, but to their landlord's assignor, because I mean it would be fantasy. It'd be a fantasy land to think that you could put into a lease a covenant that the landlord will not assign the reversion without the tenant's consent. You're never going to get that. So even if you've got a strong landlord now, they may well sell to a company that's teetering on the brink, and you as the tenant or the tenant's financier have no control over that. So I think, yeah, it's a real problem for financiers.
Where the tenancy gives permission to the bank or financier to consent to the lease, and then the liquidator seeks to enforce its rights in regard to space, wouldn't the tenant have then a right, having received consent from the mortgagee to the lease?
The question was whether, if the tenant obtains the mortgagee's consent to the lease, that consent could be then used to restrict the liquidator from exercising the disclaimer power. And I think the answer to that's got to be no, because the mortgagee is the bank who would either go into possession himself or appoint a receiver, but a liquidator is acting in a different capacity. The liquidator is appointed to the company, not and for the benefit of creditors as a whole, not for the bank as a receiver. And I just can't see why the liquidator, if the liquidator is entitled to disclaim a lease, why couldn't they just disclaim that promise?
But the tenant would then have a right against the bank on the basis of having received a consent. If you assert that the bank...
But it's not the bank disclaiming, it's the liquidator.
Yes, but the liquidator would have to meet bank's obligation as they have economical...
But I'm not sure I see how that would stop the liquidator. I'll think about it, because it'll be handy to have something.
Thank you.
Yeah, thanks, Sam. Is there any room from the Court of Appeal's decision that you could think of another property right that you could register that would run for the term that isn't contractualised?
One of the points that was raised in the Court of Appeal was that a lease is a subordinate property right in the same way that a mortgage is a subordinate property right. And if you can disclaim a lease, then you can disclaim a mortgage. They rejected that outright, presumably because you haven't got the same contractualisation of mortgage rights as you have with leases. What could you have?
Australia, or one state, you can't register or notify a covenant, so they actually find another way of attaching a covenant to another property interest, registering the property interest, so you get around the issue of an unregisterable contractual interest.
But what's the property interest?
That was what I was hoping you could invent for us.
Fortunately, they tend to be invented from the top down rather than this way. No, I'm just thinking about the answer to this. I mean, what could you do? Get some inalienable easement rights that you say, oh, I've got easements over this shop and you can do whatever you want for it, but any tenant would take it subject to my easement. Maybe. Easements, yeah, I mean, easements are sort of, there's not a huge amount of law on easements in recent years. They've fallen out of favour a lot. So I'm not aware of any sense in which they've been contractualised.
Westfield case, High Court indicated that it's an indefeasible right that you get. Certainly in New South Wales, you get title by registration, not by a contract. But it
Maybe.
Is there any benefit in registering the lease in Victoria?
Yeah, but I'll tell you why after tomorrow.
Sam, but I assume after tomorrow you'll do a blog on that special leave application?
It depends on which way. I'll say what happens, but obviously now I'm in it, there's only so much I can say about it if the case is going to run. Just on that, there's limitations. There are bar rules that prevent us from commenting in certain forums about that are critical of a decision if an appeal is on foot or is likely. So there's limitations to what I can say about it. So I'll certainly do a blog post to say what happened, and beyond that, I'll say watch this space or watch that space, the blog. For those who are a bit unfamiliar with blogs, the blog is basically just a website that has short articles published by me. It's about 12 a year that I get up there. Although the frequency of the blog posts tends to be inversely proportionate to how much work I've got on at the time. But there's a little box where you can put your email address and subscribe to the blog and get an email alert every time a post goes up, which saves you having to manually check. And so far as I can tell, I've subscribed to my own blog just to see what happens. So far as I can tell, I don't pass your email address on in any way, and you're not subject to any spam as a result. So if it does interest you, sign up to the blog and get some alerts and see what's happening. I should add, Robert Hay's got one as well that touches on similar things. I tend to be leases and insolvency, whereas Robert tends to be property as a whole, but we often talk about the same issues in the same cases. So on my blog page, there's a link to Robert's blog as well. So if you're interested in this sort of area, then click on subscribe to Rob's as well. Any other questions? Michael Trumbull had promised me a doozy of a question just to catch me out. Disappointing, Michael. Disappointing. All right, well, thanks for listening. Oh, another question?
When you're sitting here, you're thinking, how can you get around it? I'm just thinking, sorry, I'll speak up.
Sorry,
Outside of the lease proper, if a separate document was executed by the landlord and the tenant, that somehow granted the tenant an equitable charge over the property concerned in connection with the future insolvency of the landlord company. And as a result, the tenant registered a caveat over the property based on that equitable charge which is outside of the lease. The liquidator disclaims the lease. Can the liquidator then disclaim that equitable charge?
Well, what does the charge do?
The right title and interest in the property to cover the consequences of loss to the tenant in the event that the liquidator disclaimed the lease.
A mortgage fee, they become a secured creditor for the losses in relation to the disclaimer of the lease.
I don't think it may not be a perfect solution, but it may give a tenant some more comfort.
Look, it might make them I think what you're getting at effectively makes them a mortgagee of the damages for the disclaimer rather than having to prove as an unsecured creditor and the winding up.
Along those lines.
It won't secure the tenancy, but it might give them a better shot at getting some money. But you've effectively got to elevate them then to a mortgagee, and
chargee not sufficient, you'd go to the next step.
Oh well, look, and Torrens Land are the same thing, really.
Yeah.
I mean, you'd want to register it as a Torrens mortgage rather than just as a caveated charge, so that you've got better, you're more secure in your priorities. Better than not having it, I suppose. Well, that's correct. That's what I'm saying. That's the next issue. You've got to get it there. Yeah. So, I like the thinking. It's good. But I think, as you say, it's going to be hard to get the landlord or another bank to consent to those sort of things going on the title. But these things will all work their way through the system if the Court of Appeal's decision stands.
Sam, just a question. If tomorrow you say that registration doesn't overcome this issue, what about a covenant on title? Registering a covenant?
So covenant to what?
It's a covenant that runs with the land. The proprietor is given rights for the land to be used in a certain way for the harvesting of trees.
Aren't you just registering the lease at that point?
It's not a lease, it's a covenant.
Or is it an easement? Just thought of another issue that might come up with an easement. You'd need a profit. And probably, depending on the nature of the tenancy, and you might need more than a profit of prondra, which is only the ability to remove from the land, depending on what you're doing. There's some fabulous ancient law about a profit a rondra, which allows you to bury people in the land, but what you'd have to think about what the covenant does if it's not an easement, or is not a charge, or is not a mortgage, or is not actual de facto registration of the lease itself. A restrictive covenant to restrain the landowner from from.
I was thinking positive obligations as to how the land is used.
Don't know. Look, if it stands, I suspect we'll see a lot of these things being tested, and you'd have to say if you can get the landlord to agree with it, anything's worth a try. Yeah. Okay, I'm being shut down by Michael. So thanks everybody.